Okay, I think we'll make a start. Um, Welcome, everyone. My name's Tom Wainwright. I'm a member of the Garden Court crime team and one of the coordinators of the Garden Court protest team. This is a webinar brought to you by the protest team on the topic of prescribing peaceful protest. And I'm delighted to be joined by Owen Greenhall and Audrey Mogan, who are also members of the Garden Court protest team. If anyone does have any questions about any of the points and issues that we're going to discuss, then of course feel free to email us directly or through the criminal clerks, and we'll do our best to answer those. The topic of the webinar, as I mentioned, is prescribing peaceful protest, prescription of particular organisations. Their designation as a terrorist group is a subject that was in the news a great deal this year in the spring and over the summer. Prescription of an organisation as a terrorist organisation is not something that's new, but it may be that many of those who practice in crime have not encountered it or dealt with it in any great detail previously and may not be familiar with it. And that's part of the reason why we're putting on this seminar, because although the power isn't new, the use to which it's been put and the use of prescription proceedings against direct action protest groups is, it appears, a new departure, and it appears to be a new tool for the state to create a hostile atmosphere for protests. And potentially this is the start, depending on what happens with the various challenges, the start of terrorism being used. And the regime, which encompasses not just the criminal offences, which we'll cover later on in the talk, but also the police powers and other civil powers that become available when the state decides that they are dealing with a prescribed organisation, a terrorist organisation. Those may become used more broadly, and this may be an issue that more of us who practice in criminal defence will have to become familiar with. So we will start but with Owen Greenhall, who's going to give us an outline as to really the background and how we got to this point in terms of protest law. Just by way of brief introduction, as anyone who's had a passing in dealing with protest law will know Owen and his work, so he needs very little by way of further introduction. He's one of the leading barristers in protest law in the country, acting in both the criminal and civil spheres, co-author of the Protest Handbook, co-chair of the Network for Police Monitoring Lawyers group, and counsel who acted in, amongst other cases, a case of Ziegler, DPP in the Stratford Magistrates Court, the Attorney General's reference of this year on belief in consent, the Director of Public Prosecutions versus the Manchester Magistrates case, to name just a few of his more recent authorities. So with that very brief introduction, I'll hand over to Owen.
Thank you very much, Tom, and welcome to everyone who's on this webinar. I'm going to give I hope, brief overview of the state of protest law as it exists currently outside of the prescription regime, because it's important to realize that prescription does not happen in a vacuum. It is a very draconian power, but it is one which is used against the backdrop of existing legislation. So I'm going to set out how things are at the current time. So if I could please have the next slide. So in 2022, Priti Patel, then Home Secretary, introduced a raft of new legislation, which essentially sought to clamp down on the right to free speech. Of course, she started this by giving a on the face affirmation of the importance of free speech and protest, stating the right to protest peacefully and to exercise rights of freedom of speech is a cornerstone of democratic values which will always be defended by the government. However, she says, the rights to protest must be balanced with the rights of the general public to go about their daily lives free from serious disruption or harm. And she specifically made reference to what she described as guerrilla tactics that were being used by a minority of protesters to cause misery to the hardworking public, disrupt businesses, interfere with emergency services, and cost millions of taxpayers' money. She quite clearly had groups such as Extinction Rebellion, Just Stop Oil, Insulate Britain, and Palestine Action in mind when she was making those comments. If I could have the next slide. So the trend that has we have seen in the last few years has essentially been one of increasing legislation, bringing in new offences, looking to clamp down on protest. Uh, that has gone hand in hand with a removal of defences to criminal charges by the criminal courts, and also an increase in the sentencing that's been handed out to those convicted of protest offences. In terms of the legislation, if I could have the next slide. the There were two major pieces of legislation. The first was the Police Crime Sentencing in Courts Act 2022, and then later the Public Order Act 2023. And I'm just going to touch very briefly on the offences that were introduced, but the PCSCA introduced the statutory offence of public nuisance, introduced offences of obstruction of vehicle access to Parliament. It's made the offence of obstruction of the highway an imprisonable offence, and it also increased police powers to impose conditions on assemblies and processions, notably on restrictions in relation to noisy protests. It introduced restrictions on one-person protests, and it also introduced a power to the Secretary of State to amend those police powers, so to provide for new grounds on which to in which the police might impose conditions on a protest. As one brief bit of good news, that last power was subject to judicial review by Liberty, and they were successful. Liberty and others, but they were successful in quashing the regulations that were initially introduced under that power in relation to what amounted to serious disruption. But that is, as we shall see, a rare chink of light in an otherwise much more gloomy position. If I could have the next slide, please. So, and then again, just briefly, in the Public Order Act 2023, that introduced a number of further new offences relating to locking on, causing disruption by tunnelling, obstructing major transport works, also importantly, interference with the use of key national infrastructure. And key national infrastructure is there defined very broadly and includes effectively any A or B road in the entire country. It also introduced police powers to increase their powers of stop and search, both with and without suspicion. Now, so that just taken as a whole, and without going into details, is a very comprehensive legislative framework brought in, all of which is brought in with a view to restrict the right to protest. If I could have the next slide, please. And as I said, alongside the increase in legislation, there is a restriction on the defences that may be relied upon to these criminal charges. The turning point, I think, in relation to this, and the high point in terms of the availability of criminal defences to criminal charges, is still the Supreme Court case in Ziegler back in 2021. Which said that in a criminal case involving a protest offence, the prosecution has the burden to prove to the criminal standard all the facts on which it relies to establish that the interference with Article 10 and 11 rights is proportionate. And if the facts are established, then the judge or a jury should evaluate those facts to determine whether or not they are sure that the interference was proportionate. So it's a very clear statement, burden of proof on the prosecution to establish the proportionality of interference with Article 10 and 11 rights to the criminal standard. That case was immediately followed by a backlash of cases that went through the higher courts seeking to restrict the impact of, in particular, that section of the judgment. If I could have the next slide, please. And I won't go into the details of these cases, but the immediate responses were a case of Katurian and DPP, which went so far as to suggest that Articles 10 and 11 might not even be engaged in an act of trespass. There's Attorney General reference 1 of 2022, that's the Colston statue case, which said that for that criminal offences could be divided up into essentially two different categories. What those where proof of the ingredients of the offence, of the elements of the offence itself, would render any conviction proportionate, and those which required a more fact-sensitive evaluation of the proportionality of conviction. And that was picking up on a distinction first introduced in DPP and James. And that essentially said that for criminal damage above a threshold of relatively minor damage, which was well below £5,000, there would never be any need for an assessment of proportionality before convicting. That was fairly swiftly supported by the case of AGNI and abortion services, a decision of the Supreme Court, which said that actually the position is a little bit more nuanced than simply dividing all criminal offences into two broad categories, and needed a much more sensitive assessment of the factual position, but nonetheless was very disparaging of any evaluation of proportionality of conviction, certainly by a jury. The case of Casserly is a malicious communications offence, a Speech Act offence, and that sought to fold the proportionality assessment essentially into the an assessment of what the elements of the offence are. So giving certain aspects of the offence a heightened meaning, a higher threshold to establish whether or not particular conduct has crossed the line into criminality. If I could have the next slide, please. So the trend in restricting defences to criminal charges has continued in more recent cases. There have been two recent decisions in relation to public nuisance. These have addressed more other aspects of the legislation, in particular what it means for a section of the public to be affected by a protest. The case of Smith said a section of the public is simply a group within a larger group, didn't have to be a significant or substantial group in and of itself. Case of AFY considered what the rights of the public were on which a public nuisance offence might be founded. The right of the public, it has to be a right shared by all members of the public, but it can be a right which is only conditional on, is subject to certain conditions. So payment of a fee for an entry fee, the fact that you have a right to attend a certain venue only on payment of a fee doesn't mean that that is not a right of the public at large, and similarly can be a right which is exercised on private land. Then the case of Saatchi was the first case to consider the new offences and their compatibility with the need for a proportionality assessment as set out in Ziegler. And what the case of Saatchi said was that for the offence of interference with key national infrastructure, there is no need for any proportionality assessment prior to conviction. And that was despite the explanatory notes or the consideration in the development of the bill making specific reference to the fact that the defence of reasonable excuse in Section 7 was there in order to cater for the need for a fact-sensitive proportionality assessment. And the Court of Appeal quite clear that didn't matter. In their view, it wasn't necessary. If I could have the next slide, please. And so that feature where the legislature has indicated that there may be a need for a fact-sensitive proportionality assessment is also present in the Terrorism Act. There is a relatively new offence, Section 12(1)(a) of the Terrorism Act 2000. I think Tom is going to say address this in more detail, but there's just one aspect of the offence that I want to pick up on, and that is the offence is the offence of recklessly encouraging support for a proscribed organisation, so for a banned organisation, and it was noted as the bill was passing through Parliament that it was an offence which could cover could interfere with free speech quite significantly, and that there might be certain types of statement which could be captured by the offence where it would be inappropriate to impose criminal liability. In particular, there was concern about capturing debates about whether or not an organisation should be proscribed. So calls for deprescription might on their face be captured by this offence. And these concerns were highlighted by when the report was in committee stage, and the government made an official response. And their response was that it would be impractical to define on the face of the legislation in specific terms the particular types of statement that will or will not be captured. Such determinations will be highly dependent on the facts and circumstances and can only properly be made by a court considering all those matters in each case. So that is Parliament essentially handing the baton over to the courts and saying, we accept that we have very broad legislation here, over to you to work out how to implement this in practice and make this compatible with free speech rights. If I could have the next slide, please. And what is significant is that the offence of recklessly encouraging support for a proscribed organisation is one of a suite of offences, and it falls in between the more serious offence under Section 12(1) and the less serious offence under Section 13. So the more serious offence under Section 12(1) is intentionally encouraging support for a proscribed organisation. And that offence had been subject to challenge on the basis of its proportionality with Article 10 and 11 rights. And what the Court of Appeal said there was, when considering the proportionality of the interference, it's important to emphasise the section only prohibits inviting support for a proscribed organisation with the requisite intent. So it was the presence of intention that rendered that offence proportionate. And it is quite obvious that the case of Section 12(1)(a), reckless encouragement, has specifically removed that feature from the offence. So Parliament has taken out the very element which the courts had said was what rendered that offence proportionate. And similarly, a comparison needs to be made with the case of with the offence under Section 13. This is the offence of wearing a uniform or displaying an article that gives rise to a reasonable suspicion that a person is a supporter or member of a proscribed organisation. And that is a much more minor offence, a summary-only offence. The Supreme Court held that that was essentially a strict liability offence. And when it was challenged as to whether that was a proportionate interference with free speech rights, the Supreme Court said that a fair balance had been struck between the rights of free speech and the aims of the legislation, because and said this is primarily because the criminal sanctions are comparatively minor, and noted the low sentences that are often passed for that offence and the fact that it didn't have all the ramifications that came with some of the more serious offences. Well, Section 12(1)(a) is very much a serious offence. It falls on that side of the line in terms of of the sentencing powers, in terms of it's an either way offence, all the rest of it. So again, the very element which rendered the Section 13 offence compatible with Articles 10 and 11 has been removed from the Section 12(1)(a) offence. So given that how the legislative scheme works and where Section 12(1)(a) fits, um, the challenge was then, well, how can it, how can you say that Section 12(1)(a) is compatible with Articles 10 and 11? This was not something which troubled the Court of Appeal in the case of ABJ and BDN. They were satisfied that whatever differences there might be between sections 12(1), 12(1)(a), and section 13, they were not so significant as to give a different outcome in terms of the proportionality assessment, and essentially held that there was no requirement to consider free speech rights when assessing whether an offence under section 12(1)(a) has been committed. That case, I should say, it has been leave has been granted for an onward appeal to the Supreme Court, and that will be considered later this year. So that sets out in general terms a quite clear restriction on the types of defences that may be relied on in criminal proceedings arising from protest. And that applies across the board from standard protest offences to new protest offences, and also importantly in relation to terrorism offences, where those offences touch on free speech rights. If I could have a final slide, please. And just to touch on the final element of the bleak picture I've presented in terms of protest rights in this country, I come to sentencing in protest cases because it's very clear that there has been a very marked increase in some of the sentences which have been handed out, particularly for the more for seriously disruptive protest. We had the case of Trowland and Decker. That was a protest which blocked a bridge over the Thames for a number of days, caused very significant disruption to traffic. Sentences of in the region of 3 years were upheld for persons convicted after trial in that offence. That that in itself was considered to be a very harsh sentence. It was then followed by the cases of Hallam and others. These were conjoined appeals, many of which related to conspiracies to block the M25 over a number of days. And even higher sentences were imposed in that case. So 5 years for Roger Hallam in the most significant case, and other cases, all of immediate imprisonment, going down from that. Those sentences were appealed to the Court of Appeal Criminal Division. The Court of Appeal did reduce the most significant sentences. So the sentence for Roger Hallam came down from 5 years to 4, and consequential reductions in some of the others. But notably, they did uphold sentences of immediate imprisonment for conduct which in the past would never have received anything like that sort of sentence. The court did deal in some detail with the scope of Articles 10 and 11, and in particular, the scope of Article 10 versus Article 17, said it was a very high threshold for conduct to fall outside the scope of Article 10 altogether. It confirmed that simple actions of criminal damage, like throwing soup onto a painting, were not violent in any sensible meaning of the word, and that didn't take them outside the scope of Article 10 and 11. Confirmed that Article 10 and 11 remained engaged during acts of trespass, which is again a significant finding, and may be useful for other cases in the future. And the case did emphasize the importance of conscientious motivation when it comes to culpability. But overall, when one looks at the combination of legislation, removal of defences, and increased sentencing, we have a very restricted climate for free speech before we even come on to talking about proscription. I'll hand over to Audrey for the next part of the talk.
Just briefly introduce Audrey before we hand over to her to cover the procedure for proscription. To say, for those that don't know Audrey, she is one of the stars of protest law in the country, ranked in chambers and partners for her work in this area, having represented over the years Palestine Action, Just Stop Oil, Insulate Britain, Extinction Rebellion, Black Lives Matter, and many, many other organisations and, of course, individuals, and across all areas of the country and all levels of court proceedings. So with that very brief introduction, I'll hand over to Audrey.
Thanks, Tom. Evening, everybody. So I guess as Owen said, just when you thought it couldn't get any worse, it does for our protesters. I'm going to talk a bit about the procedure and looking at effectively the Terrorism Act 2000 to go through proscription, because that is the newest thing that's been levied at protesters and protest organizations. So if I could just have the first slide, please. I'll be very upfront with you. We're going to be looking at the statute, which I know you all can read yourself, but I will try to throw in some interesting points where I can. The statutory definition of terrorism comes from Section 1 of the Terrorism Act 2000. Just to highlight a couple of things here, you can see what it says is the use or threat of action where the action falls within subsection 2. And you can see under 1.1b, the use or the threat is designed to influence the government or an international government organization, or to intimidate the public or the section of the public. And then you've got that the purpose is for advancing a political, religious, racial, or ideological cause. And here's where we get to, I guess, the most interesting part. Action falls within this subsection if it, A, involves serious violence against a person, B, involves serious damage to property, and then we've got C, endangers a person's life, other than the person committing the action, creates a serious risk to the health and safety of the public or a section of the public, or E, is designed to seriously interfere with or seriously to disrupt an electronic system. Obviously, the elephant in the room, and what we're really talking about when we talk about protesters is, well, at least for now, is Section 1.2b and this serious damage to property. If we can go to the next slide, please. So the statutory framework relating to proscription is set out under Section 3. This effectively states that an organization is prescribed, and again, I'm sure everybody on this webinar knows what I mean, but effectively prescribing an organization to say it falls under the terrorism legislation, that it is a terrorist organization for the purposes of this legislation. It would be listed in Schedule 2, or it operates under the same name as an organization listed in that schedule. So what that allows, and I haven't put in all of the entire statute, again, you can find that yourself, but what it does mean is there are circumstances with it where a group could be put into Schedule 2, and then it is argued that a separate group who does the same acts and has the same aims and falls under the same kind of terrorism definition and has the same purposes could be, well, sorry, this isn't the part here at Section 3.1b, but effectively another point is that you don't, even if you're not listed under Schedule 2, but you are supposedly a similar organization, you can also be found to be subject to the provisions of this act. Here we've got under Section 3.2, it will not apply to a Secretary of State. It doesn't apply in relation to an organization listed in Schedule 2 if it's subject to a note, but it's 3 by order. So it's by statutory instrument, the Secretary of State will add an organization to Schedule 2, or can, as you can see under 3B, remove an organization or amend that schedule in some way. And again, we've got here under section 4, section 3, 4, and 5, the power is exercised in respect of an organization only if the Secretary of State believes that it is concerned in terrorism. And again, what that means is commits or participates in acts of terrorism, prepares for terrorism, promotes or encourages, or is otherwise concerned. And then we go back, of course, to the definition in section 1, which again, as I've already mentioned, includes criminal damage. But what it effectively is saying is an organization can only be proscribed if the Secretary of State believes that they are concerned in terrorism. There's also Home Office policy. So if we can move to the next slide, I hope that that's where that is. Yeah. What determines whether prescription is proportionate? This has been updated, interestingly, as recently as the 11th of July of this year, though I don't actually think much has changed. What it does obviously demonstrate is that there is a discretion here. And these are the 5 discretionary factors that were set out in Parliament, which is the nature and scale of the organization's activities, the specific threat that it poses to the UK, the threat that it poses to British nationals overseas, the extent of the organization's presence in the UK, and the need to support other members of the international community in the global fight against terrorism. So if we can move to the next slide, this is about procedure. As I already mentioned, an order under Section 3(3) of the Terrorism Act would need to be made by statutory instrument, and then that instrument should be laid before and approved by each of the Houses of Parliament. There is a provision under Section 1235 where, because of the necessity of urgency, it can be done without the draft being approved. But that will only have effect for a period of 40 days. But this effectively, Section 123 sets out the fact that it shall be made by statutory instrument. So deprescription, an application can be made to the Secretary of State to effectively remove the organization, to deprescribe the organization, and to stop it from being treated as a prescribed organization, and with everything that comes with that, which obviously Tom will talk about. Pursuant to the, sorry, I don't have it on my slide, but I think it's the 2006 regulations, Secretary of State effectively has 90 days to make that decision. And it's effectively an application to deprescribe. And that, yes, and if we can move to the next one, if deprescription is refused under Section 4, the organization, the applicant, can appeal to what's called the Proscribed Organizations Appeal Commission, POAC. And generally, the chairman of the POAC is usually the same as the chairman of SIAC, and then other kind of judicial kind of members. But effectively, so what happens is you apply to have your organization deprescribed. Secretary of State has 90 days to decide whether or not she's going to do that. She decides not to do that. The next step, according to the statute, is to go to the Proscribed Organizations Appeal Commission. And it's set out in detail here. What is currently being considered and will not necessarily decided, but what will be ventilated this coming Thursday is the potential for judicial review of the decision to prescribe and the supervisory jurisdiction of the courts via judicial review when as you can see here, there is a statutory provision for deprescription through a prescribed through the POAC route. So stay tuned. We'll see what happens with that. But now that's all kind of the legislation stuff I wanted to talk about. If we can move to the next slide. Let me just remind, yes. I think what's a little bit more interesting than me just reading statute out to you is just what was said when at that time as well, it was Labour who was bringing in the Terrorism Act 2000. It's obviously clear that the point of prescribing an organization is basically to make it to cause it to cease to exist. That's what it is. It isn't about changing behavior, etc. And that itself was said by the independent reviewer of terrorism. So it's interesting. I mean, interesting is probably not the only way to put it, but probably heartbreaking and many other things to think that this is now an avenue that's being levied at protest organizations. But effectively, what I've got there is during the second reading of the Terrorism Act 2000, Jack Straw, who was the Home Secretary at the time, said this about what terrorism involves. And it's interesting to look at what he said at the time and compare that to what generally we think about protest organizations. So you can see it here. And of course, as Tom's already mentioned, you can have the slides. But this threat or use of serious violence, the creating a climate of extreme fear, and interestingly here, although all crime to some degree plainly threatens the stability of the social and political order, terrorism differs from crime motivated solely by greed in that it's directed at undermining the foundations of government. And it's all about this kind of undermining liberal democracies and the idea of this kind of expressing opposition and dissent in this violent kind of way. So arguably reading this, it wouldn't take someone by surprise. This sounds like what you might think terrorism is. Interestingly, during these debates, there was significant discussion and questions from probably the usual suspects like Jeremy Corbyn, John McDonnell, Audrey Wise, just about the inclusion of criminal damage in the definition and what that might mean for certain direct action groups. At the time, they were talking about, there's a lot of animal liberation groups. They were talking about things around genetically modified crops, Greenpeace, stuff around the plowshares, East Timor. There was quite a few concerns and questions, stimulating Hansard reading about how the fact that criminal damage is included in the definition of terrorism. And it's not and criminal damage, criminal damage itself it is simply there. Now, so if we can move to the next slide. And this was a response from Charles Clarke, who's Minister of State at the time, and just referring to kind of questions around Greenpeace. And you can see here, I've come back to the core of the definitions, the general issues concerning the use of threat, purpose of advancing a political, religious, or ideological cause, or seeking to influence the government. Again, obviously the concerns were, well, if you're a protest group, some protest groups, the idea is to protest to get the government to change something or another. And as Charles Clarke here says, clearly most direct action falls within those categories. But interestingly, in the scope of the bill, it must involve one of the 5 things. And the first is serious violence against the person. The second is serious damage to property. And then goes on to say this, that is far beyond the way in which one could categorize a Greenpeace vessel bumping something else on the high seas. Don't need to go into the rest, but as you can see at the end paragraph, those are pretty those are all pretty serious hurdles. And here, just to be clear, he says here, we don't seek to apply the legislation to any domestic. At this time, in the passing of the original bill, it was not domestic organizations, but then that, of course, did come to pass. Just because I do think it is quite interesting. I have some others that I don't have them on my slide, so don't worry about that, Sophia. But it's other things that were said. Again, Jack Straw himself said things like, many of us have been involved in peaceful protests, and I defend the right of peaceful protests. We are not talking about demonstrations that get out of hand. Instead, the bill focuses on the opposite end of the spectrum. It's about deterring, preventing, and where necessary, investigating heinous crime. Heinous because terrorism seeks to destroy not only lives, but the foundation of our society. So this is Jack Straw at the time. Now, he does go on to say, in all fairness, that if people are killed or injured, the fact that the bombs, the shrapnel, and the glass carry a label marked animal rights or the name of some foreign country is immaterial to those who suffer. But again, there is quite a lot of focus on the impact and kind of violent impact on individuals. There was a lot of discussion again around, and this was Charles Clark, about groups, and as he called them, the so-called Justice Department of the Animal Liberation Front, and talked about the incendiary attacks on shops and other premises, letters and parcel bombs. But again, whilst they were referring to protest groups and damage, you can see again what they kept referring back to was things like car bombs into attacks on scientists, and one in which a baby was hurt, fire bombs in shops in Newport. Again, there was a lot of that in the response to everybody's concern about this inclusion of criminal damage. The response from the government at the time was very much, this is something extra. This is something outside, because of course, terrorism is not just your regular criminal offenses. So I just thought I would share some of that with everybody. But that is as much as I have to say about this depressing development. And Tom will talk about all the things. Again, as I've said, the whole purpose of prescription is to completely erase an organization, to stop it from its existence. And that means what comes with it is serious sanctions for anyone who supports or shows support for such an organization. Tom's going to talk about that now.
Thank you very much. Hopefully that internet difficulty should be resolved now, because what I want to cover is a bit of a whistle-stop tour through the consequences of prescription. Now, not every act that's covered by the terrorism legislation relates to a prescribed group, but it does have wide-ranging implications for an organisation to be designated as a prescribed organisation, and therefore equated with a terrorist group. And we will have a look at those, and what those are so far as criminal offences are concerned, in the course of the next 20 minutes or so. Could we have the first slide, please? What I'm going to cover, I've bracketed the criminal offences into three groups: those which directly refer to prescribed organisations, those which involve prescribed organisations because their actions are equated with the actions or purposes of terrorism, and thirdly, those that factor in through the definition of acts of terrorism in the Terrorism Act of 2006. And then I'll briefly touch on sentencing after that. What this doesn't cover, because there isn't time, is the scope of police powers in relation to terrorist offences, in terms of forfeiture, detention at the police station, and things of that sort. It doesn't cover civil powers that the state can wield against those suspected or believed to be involved in terrorism. And it doesn't cover the impact that even an arrest for a terrorist offence can have on things like employment, on immigration, and on travel around the world. So can we have the next slide? Looking first at direct references in the Terrorism Act to prescribed organisations. First of all, membership of a prescribed organisation. Someone commits an offence if they belong or profess to belong to a prescribed organisation. Professing is something which Lord Bingham noted in the Attorney General's reference for 2002 case. Is uncertain. It wasn't held to be so uncertain that it offended the European Convention, but it was raised as a concern because it is so widely drawn that potentially it may cover people whose conduct should not properly attract criminal sanctions. We'll see that it's a theme of this legislation that it is extremely widely drawn, that it's often, as Owen and Audrey have already covered, subject to assurances when it goes through Parliament, as many other protest cases, offences are, that it won't be used in a disproportionate way. And we will see that that's almost always not how it actually pans out and how it comes to pass, and those assurances are not worth the paper or vellum that they are written on. Case of Ahmed and Ahmed was one which was touching on membership because, as the courts have noted, organisations, terrorist organisations, and other organisations which may be captured by the prescription process don't hand out membership cards. They don't always require an oath of allegiance or anything formal. Whether someone is a member of an organisation, whether they belong to it, can be a matter of fact for the jury to determine. And it's suggested in the commentary in Archbold that important factors will include voluntary and knowing association with others in a particular organisation, with a view to furthering the aims of the organisation. So associating with those who are themselves professing to be members may be enough. It's suggested for someone to be a member themselves. Let's have a look at the next slide. And I say it's really is a whistle-stop tour, because this is now section 12 of the Terrorism Act, which Owen's covered in some more detail, both section 1 and section 1A. So inviting support for a prescribed organisation, and 1A expressing an opinion or belief that is supportive of a prescribed organisation recklessly. So seeing a risk that someone will be encouraged to support them by what you say. Just a little bit on this on the next slide. So if we can have a look at the next slide. Section 12.1 was addressed in the Court of Appeal in the case of Chowdhury, as to, first of all, what did inviting support mean? Was it just practical, physical, tangible support? And the Court of Appeal said no, it can include intellectual support. It went on to say that it did not cover, the offences then drafted did not cover expressing intellectual or moral support for a prescribed organisation, so that was fine. Expressing personal belief or approval of a prescribed organisation. And it didn't cover inviting another to share such an opinion or belief. Now, just pausing there before we come on to the response to that, the difference between inviting intellectual support for a prescribed organisation and inviting another to share your personal approval for a prescribed organisation isn't very clear. On one view, inviting intellectual support, which would be an offence under section 12(1), would involve more of a detailed analysis and justification for the arguments in favour of a particular organisation. And it seems odd that that would attract criminal liability, whereas the bold assertion without justification to support a particular group wouldn't, and just inviting blind support for a group wouldn't be caught by section 12(1) seems like a distinction which is hard to justify. But the governments at the time weren't happy with the outcome in Chowdhury, even as it was, and sought to broaden it by introducing section 12(1) capital A, which introduced the recklessness basis for criminal liability, and that is subject to the decision now in ABJ, which has been before the Court of Appeal. It's going to be heard by the Supreme Court in the next couple of months, addressing 2 points, which Owen's already mentioned. Whether knowledge of prescription is an element of the offence, and whether or not the recklessness offence is compatible with Article 10 of the European Convention. This raises really difficult issues, particularly for direct action protest groups, because one asks, if you express support for a particular type of action, such as direct action, in support of a particular cause, if that sort of direct action is currently only being carried out by one particular organisation, are you at risk of committing one or other of these offences? Is being critical of the decision to prescribe a direct action group in principle, where that prescription is only being taken at the moment in relation to one particular group, does that amount to expressing support for the organisation or group that is currently being prescribed? And does even debating that, raising criticism, amount to the commission of a criminal offence in these circumstances? The position is not clear, and the ability to have that debate, the impact on free speech, the chilling effect on the right to protest, in my view, is a clear and present danger. Can we have the next slide, please? I just mentioned there the other offences under section 12, arranging a meeting to support a prescribed organisation, to further the activities of a prescribed organisation, or to be addressed by someone who belongs to a prescribed organisation, is a criminal offence, as is addressing a meeting where the purpose is to encourage support for a prescribed organisation. Skip on to the next offence, section 13. So this is wearing a uniform or publishing images. It's not actually limited to uniforms. It includes wearing, carrying, or displaying an article. So it's been applied to placards, rucksacks, headbands, things of that nature, in such a way or in such circumstances as to arouse reasonable suspicion that he is a member or supporter of a prescribed organisation. As Owen said, this is a summary-only offence. The maximum sentence is 6 months. In fact, in many cases, and in the PWR case itself, which we'll come on to next, the sentence imposed were mostly conditional discharges. But of course, that doesn't deal with all of the problems that a conviction for terrorism can cause, as we've already mentioned. That's been the justification for it being treated in the way that it is by the Supreme Court. But this offence is one which is committed where what you are wearing or holding, as the case may be, is done in such a way as to arouse reasonable suspicion that you are a member or supporter of a prescribed organisation. So this isn't just slogans or written words, it can include symbols or slogans that need interpreting, which the person holding it may not be familiar with, may not know that it's giving rise to a reasonable suspicion. But because it's a strict liability offence, that doesn't prevent criminal liability from attaching. It is so broad that it would include, by being satisfied where it would arouse reasonable suspicions, it would include situations where further inquiries would show unequivocally that suspicion was in fact misplaced in the particular circumstances. It is extremely broad. And if we can have a look at the next slide. This has been addressed by the Supreme Court, who've given those arguments short shrift. They confirmed it is a strict liability offence. The Supreme Court have decided it's compatible with Article 10. And they justify it on the basis that it is designed to deny a prescribed organisation the oxygen of publicity or a projected air of legitimacy. It seeks to avoid others becoming aware of and potentially becoming supporters of prescribed organisations. We'll come back to the aim of the prescription regime in relation to some of the other offences. Let's have a look at the next slide. Because whilst we're talking about the scope of these offences, they are international in their jurisdiction. So Section 17 of the 2006 Act provides that if someone does something outside of the UK, if it would amount to a criminal offence, one of the criminal offences listed in subsection 2 of section 17, if it was done in the UK, then that person can be convicted in the UK of that offence. Now, subsection 2 includes section 11, so that's membership, professing membership of a prescribed organisation, and that applies irrespective of whether the person in question is a British citizen. So someone who is not a British citizen, has never been a British citizen, who isn't based in the UK, if they say anywhere in the world that they are a member of a prescribed organisation, they have committed an offence in the UK. Section 12 and 13, those are limited to UK nationals or people who are UK residents at the time of committing the offence, but still can be committed anywhere in the world. Can we go on to the next slide, please? Again, just really running through these very quickly, because it's not just offences which specifically within the body of the legislation itself on that particular section refer to prescribed organisations that we're dealing with, because section 1.5, the definition of terrorism in the 2000 Act, states that a reference to action taken for the purposes of terrorism includes a reference to action taken for the benefit of a prescribed organisation. So if we look at the next slide, for the first example of this in fundraising, so fundraising Offence is an offence if someone invites another to provide money or other property and intends that it should be used, or has reasonable cause to suspect that it may be used for the purposes of terrorism. We can replace purposes of terrorism with benefit of a prescribed organisation, because section 1.5 says that that is included in purposes of terrorism. And so the raising funds for the benefit of a prescribed organisation is a criminal offence. I've highlighted reasonable cause to suspect. That's a common theme through the fundraising sections of the Terrorism Act that we're just going to run through, that we'll discuss at the end. If we can have a look at the next section, section 16 is using money or other property for the purposes of terrorism or for the benefit of a prescribed organisation. And section 16.2, it's an offence to possess money with the intention that it be used, or that having reasonable cause to suspect that it may be used for the benefit of a prescribed organisation. There seem to be, on a reading of section 16, two offences there, one where the money's actually been used, and one where there's an intention that it is going to be or may be used for the benefit of a prescribed organisation. Only the second of those appears to have any mental element or mens rea to it. I can't find any authority in which section 16.1 has been used. It may be that the authorities are seeking to avoid the potential difficulties that may cause, because these are not summary-only offences that we're dealing with. They're punishable by substantial periods of imprisonment. And so it would be more difficult for the courts to interpret these as strict liability offences. Can we go on to the next slide? Section 17 is funding arrangements. So again, precursor perhaps to money actually being transferred or provided to a prescribed organisation, simply entering into an arrangement where you have reasonable cause to suspect that that's what's going to happen is enough for the offence to be made out. And so going on to the next slide, what does reasonable cause to suspect mean? Well, it means you don't actually need knowledge, you don't actually need suspicion that that's what the money will or might be used for. It can apply to someone who doesn't, in fact, suspect that maybe. For example, because they have particular issues, subjective issues in their own particular circumstances, which means that although perhaps the average member of the public would have suspected, they in fact did not, and yet the provisions here make them liable for a serious criminal offence. And that has been justified in the case of Crown against Lane and Letts in the Supreme Court on the basis that the gravity of the threat of terrorism justified attaching criminal responsibility to such a person. And Parliament was entitled to conclude that in the circumstances that someone who did not suspect but had reasonable cause to suspect could and should be found guilty of such an offence. On to the next slide. Okay, so money laundering, section 18, facilitating retention or control of terrorist property having been defined at section 14 to include money or other property likely to be used for the purposes of terrorism, which say specifically includes any resources of a prescribed organisation. And then just lastly on this section, on the next slide, there is a disclosure, a duty of disclosure of information. There's a lot of detail, which I haven't replicated in the slide, on this offence, but the short summary is that it can be an offence not to disclose to the police or to the NCA information that's come to you in the course of a trade, business, or profession, other than in the regulated sector, which has its own procedures elsewhere in the Act. It can be an offence if you believe or suspect someone else has committed one of the fundraising offences, and you don't disclose it, subject to the reasonable excuse defence and subject to legal privilege if it comes in the course of legal relationship that's subject to the legal privilege. Can we go on to the next slide? Acts of terrorism is another route through which prescribed organisations can have a bearing on criminal offences or be subject to criminal offences. So the Terrorism Act 2006, in the definition section, says that acts of terrorism in that part of the Act, which is Part 1, which sets out all of the offences in the 2006 Act, and it says that acts of terrorism include anything constituting an action taken for the purposes of terrorism within the meaning of the Terrorism Act 2000, and the specific reference to Section 1.5, which I've repeated it here to remind us, says that action taken for the purposes of terrorism includes a reference to action taken for the benefit of a prescribed organisation. So you follow that through, and what that means is in the Terrorism Act 2006, whenever you see the words act of terrorism, that includes action taken for the benefit of a prescribed organisation. And that is intended to be so. It's made clear in paragraph 19 of the explanatory notes to the 2006 Act. How that works through, we can see if we put together the rest of the 2006 Act. Have a look at the next slide. So the offence of encouragement of terrorism, first of all, applies to statements likely to be understood by a reasonable person as direct or indirect encouragement or other inducement to some or all of the members of the public to whom it's published to the commission, preparation or instigation of acts of terrorism. So that's the sort of statements which can amount to encouragement of terrorism. Let's go on to the next slide. It's an offence to publish such a statement or cause someone else to publish such a statement if at the time you intend members of the public to be directly or indirectly encouraged or otherwise induced by it to commit acts of terrorism, or are reckless, whether if you foresee a risk that people will be induced by your encouraging statement to go and instigate similar acts themselves. On to the next slide, because that provides some information about or definition of what can be or what statements that are likely to be understood by a reasonable person as indirectly encouraging the commission or preparation of acts of terrorism includes, and that those statements include every statement which glorifies the commission or preparation, whether in the past, in the future, or generally, of such acts or offences. So any statement which glorifies or which members of the public may infer is glorifying previous conduct of prescribed organisations, and if members of the public may infer that what you're saying is this is a good thing, you should emulate these previous acts all of prescribed organisations, then that is a statement that's likely to be understood by a reasonable person as indirect encouragement. And putting it together just by way of a summary and perhaps as an example on the next slide, what that can mean is that a person commits an offence if they publish or cause to be published a statement which glorifies the past, future, or general commission of acts taken for the benefit of a prescribed organisation. So glorifying previous direct action taken for the benefit of an organisation which is prescribed, for example. If members of the public may or could reasonably be expected to infer that conduct, glorification of direct action is intended to encourage them to do similar, and the person who publishes it intends or sees a risk that members of the public will be so encouraged or induced by that action, which makes discussion of the topic even more difficult, let alone criticism of such actions in terms of, or criticism of prescribing or organisations in relation to such actions. It makes the public debate even more limited. If we have a look at the next slide, Section 5, preparation of terrorist acts, very broadly drafted. A person commits an offence if, with the intention of taking action for the benefit of a prescribed organisation, they engage in any conduct in preparation for giving effect to their intention. And just very briefly on the next slide, having had some examples of how prescribed organisations, acts taken for the benefit of prescribed organisations can feature in the 2006 Act offences. I haven't covered all of them. I haven't covered all of the ones in the 2000 Act. But there are offences such as disseminating terrorist publications, which include perhaps pamphlets or documentation which relates to prescribed organisations. Training or attending at a place used for terrorist training would also be further offences which are in issue. Final slide next. Really just flagging these up as the headlines as to the impact of being convicted of an offence involving a prescribed organisation. And those who've dealt with sentencing for any sort of terrorist offence know that it's a minefield, and the regime is tough, if not draconian. The courts consider whether or not the offence has a terrorist connection. Particular offences can be designated or are designated as serious terrorist offences, meaning that extended sentences of significant length can be imposed, even if they aren't. Special sentences for certain offenders of particular concern apply, which impacts a defendant's release date from custody, when their case can be considered by the parole board, how long additionally they have to serve on licence once the offence is completed, and even once all that's done, and on top of that there is the terrorist notification requirement scheme set out in Part 4 of the Counter-Terrorism Act of 2008, which imposes further obligations on those convicted of such offences. So that is a very, very quick run through, and I think that's all of the slides that we're going to go through this evening. As I said at the start, because of the nature of the offences that we're dealing with, to a degree, the extremely broad scope of the criminal offences that apply, which can create a minefield for discussing these issues, but predominantly because there are ongoing proceedings. We aren't dealing with questions and answers or comments as we would normally do. Please do drop us a line if there are particular issues that you'd like to ask any of us about. I think just instead, sort of thanking my fellow panelists and thanking you all for joining us, I was just going to make a few observations. The constitutional lawyer and journalist David Alan Green's been publishing quite a lot recently about the recent prescription decisions and what that says about the state of the criminal and constitutional law. And he made the point, I think, in a post yesterday, that terrorism law is supposed to be something that's exceptional, that's justified because it's outside the usual scope of the criminal or the civil law, and particular extraordinary powers are required in order to deal with it. Up until the 2000 Act, most of the legislation was enacted on the basis that it was temporary, and it says so in much of the titles of the legislation, the temporary provisions. This idea that it was just to deal with the ongoing state of emergency, and that in the fullness of time, once that emergency was dealt with, it would lapse. In fact, as could have been predicted, and I'm sure many did predict at the time, rarely, if ever, does anybody that granted power of any sort willingly give it up in due course. And instead, what we've seen is the state accumulate further powers to itself to wield these extraordinary and draconian powers against individuals and groups who are not in favour with it. Sometimes with stronger justification than others. Sometimes where justification is weak or lacking, perhaps. But we've seen, as we've covered in the course of this talk, that assurances about how the powers are going to be applied, the availability of the scope of defences have not been adhered to, and they've been given very little weight by the courts in deciding whether or not the offences should be viewed through the lens of proportionality, whether or not the availability of a defence should be left to the jury or not. And instead, it appears that the courts have justified and upheld the powers that the state has accumulated, referring again to the unusual nature of the threat when one is dealing with terrorism. The regular procedures aren't sufficient. But where the terrorist legislation has been expanded to include protest groups, then perhaps time's come to ask whether those justifications still hold sway, or whether continually deferring to the government's decisions about prescription and doing nothing to challenge or allow challenge in the criminal courts to those decisions has meant that the court's duty and the power of the jury to act as a bulwark against the erosion of our civil liberties has been damaged through this process over the years. And these are steps that have been taken, as Audrey's noted, by a Labour government. The position in the future, should a far-right government come to power, if the court's willingness and ability to keep such extraordinary powers in check has been eroded by that stage, then that may be a decision that many will come to regret, not doing something more to protect at this point. So with those final thoughts, thank you very much everyone for attending this evening, and that concludes this webinar.